It was 4:50 on a Friday afternoon when a property manager changed the locks on a disabled single mother's apartment, piled her family's belongings onto the curb in the rain, and told her, in front of her two young children, that she had exactly 1 hour to remove whatever she could carry before the rest would be thrown away. She didn't scream. She didn't argue. She sat down on the wet curb next to a broken dresser drawer, pulled her 7-year-old daughter and her 4-year-old son close against the cold, and made one phone call. She didn't call a lawyer. She didn't call the police. She called her older brother, a man who 6 hours later would personally sign an emergency order that would end that landlord's business, freeze his assets, and open a federal investigation into a pattern of illegal evictions stretching back nearly a decade. Her name was Danielle Voss. Her brother was the Honorable Marcus Voss, a sitting United States District Judge. This is the story of what happens when a system built to exploit people who have no one to call finally runs into someone who does, and what happens next when the person on the other end of that phone call turns out to have the power to bring an entire company down before the weekend is even over. Stay with us, because before this story is finished, you're going to understand exactly how long this landlord had been getting away with this, and exactly how many families before Danielle never had a brother with a federal bench to call. Every eviction Briarwood Property Group had executed before that Friday afternoon had followed the exact same quiet, calculated logic. Find a tenant unlikely to fight back, build a paper trail, move fast, and count on the fact that most people facing eviction have neither the time nor the resources to challenge a company that does this for a living. That logic had worked, without exception, for nearly a decade. It was about to meet the one variable it had never accounted for. Danielle Voss was 34 years old, raising 2 children alone in a 2-bedroom apartment on the outskirts of the city, working part-time as a medical billing coder from home. One of the few jobs her body still allowed her to do since a car accident 4 years earlier left her with chronic nerve damage in her lower back, and a disability rating that made full-time employment, and the health insurance that came with it, permanently out of reach. The accident that changed Danielle's life happened on an otherwise unremarkable Tuesday morning, when a delivery truck ran a red light and struck her sedan broadside as she drove her children to school. Mia, then 3 years old, and Ethan, not yet born, were both unharmed, a fact Danielle has said she thinks about every single day since, grateful in a way that colors everything else about how she talks about her own injuries. Danielle herself spent 6 weeks in the hospital, underwent 2 spinal surgeries, and emerged with permanent nerve damage that left her unable to stand or sit for extended periods without significant pain, and unable to safely lift either of her children the way she once had. She rebuilt her life methodically over the following years, training for remote work she could perform from home, learning to manage a body that no longer cooperated the way it used to, raising 2 children largely on her own after their father, unable to adjust to the realities of Danielle's new physical limitations, left the marriage roughly a year after the accident. She rarely described any of this to people who met her as tragic. She described it, when she described it at all, simply as the shape her life had taken, and one she had learned to build a stable, loving home around, one careful day at a time. She and her brother Marcus had grown up close, despite very different paths. Marcus building a career that eventually led him to the federal bench, Danielle choosing to stay near their aging parents, working steady jobs, raising her kids in the same working-class neighborhood where the two of them had grown up together. Marcus never let his career create distance between them. He called Danielle every Sunday without fail. He showed up for both of his niece and nephew's birthdays every single year, no matter how demanding his docket. And he had, on more than one occasion, quietly helped Danielle cover unexpected medical bills that her disability payments alone couldn't stretch to cover, always without making her feel like charity, always framed simply as what family does for each other. Marcus's own path to the federal bench had been, in its own way, shaped by the same working-class neighborhood that raised them both. He often told law students, during guest lectures he gave at his alma mater, that he'd decided to pursue law after watching their own parents struggle for years with an unfair landlord dispute of their own. A memory that, once the events of that Friday afternoon unfolded, several close friends privately noted felt almost impossible to separate from how quickly and instinctively he moved to help his sister. "I grew up watching my parents feel powerless against people who had more resources and more knowledge of the system than they did," he said in one lecture, recorded years before Danielle's own case, that later resurfaced once the story became public. I went into law because I wanted to understand that system well enough to make sure my own family, and eventually other families, never had to feel that powerless again. What Danielle rarely mentioned to her brother, out of a mixture of pride and a genuine desire not to burden him with problems she believed she should be able to handle herself, was exactly how difficult her housing situation had become over the previous 18 months, since her apartment complex changed ownership and came under the management of a company called Briarwood Property Group. Briarwood, it would later come out through the federal investigation triggered by Danielle's case, had built its entire business model around an aggressive, systematic approach to what internal company documents, later obtained by investigators, referred to internally as portfolio optimization, identifying tenants on fixed incomes, disability benefits, or housing assistance programs, and using a combination of minor lease technicalities, selective code enforcement, and, in the most severe cases, illegal lockouts, to push those tenants out in favor of renters who could be charged significantly higher market rates. Danielle had become, without fully realizing the scope of what was happening to her, exactly the kind of tenant Briarwood's business model was designed to remove. Her rent, technically below current market rate due to a legacy lease agreement from the building's previous ownership, represented, according to those same internal documents, nearly 40% below what the unit could command if released to a new tenant. She had, over the previous year, received 3 separate notices citing minor lease violations, a delayed rent payment during a month when her disability payment had been held up by a processing error entirely outside her control, a complaint about noise from her children playing in the shared courtyard that no other resident had actually filed, and a citation for a wheelchair ramp she had installed at her own expense, with prior written permission from the building's previous management, to accommodate the mobility aid she increasingly relied on as her nerve damage progressed. The first notice, the late rent violation, arrived with a $150 late fee attached, despite Danielle providing documentation the very same week showing the delay originated entirely from a processing backlog at the Disability Benefits Office. Documentation Briarwood's office accepted for the fee reduction, but which, investigators later noted, was nonetheless permanently entered into her tenant file as a recorded violation, regardless of the fee ultimately being waived. The second notice, regarding noise complaints from her children, troubled Danielle more than the others, specifically because no other resident in the building had actually filed any such complaint, a fact she confirmed herself, somewhat uncomfortably, by asking her immediate neighbors directly, all of whom told her they'd never had any issue with her children and had filed nothing. She raised this discrepancy with the property office at the time and was told only that the complaint had come through a corporate tenant relations line rather than a resident directly, an explanation that, at the time, struck her as strange but not alarming enough to pursue further, given everything else she was already managing. Each notice, individually, had seemed to Danielle like an isolated, frustrating bureaucratic headache, the kind of thing she assumed happened to tenants everywhere, the ordinary friction of renting from a company that didn't know or care about the specifics of her situation. She resolved each one as best she could, paying late fees she couldn't really afford, writing appeal letters, gathering documentation. What she didn't understand, because she had no way to see the pattern from the outside, was that each resolved complaint was simply setting up the next one, a slow, methodical accumulation of paper trail that Briarwood's legal team was using to build a case for eventual eviction, regardless of how thoroughly Danielle addressed each individual issue as it arose. The final notice arrived on a Tuesday, cited a supposed violation of the property's unauthorized modification clause, the same wheelchair ramp that had previously been approved, and gave Danielle 5 business days to either remove the ramp entirely or vacate the unit. Danielle, working with a legal aid clinic she found through a local disability advocacy nonprofit, filed a formal objection within the required window, citing both her prior written permission from the previous ownership and federal fair housing protections that explicitly prohibit landlords from penalizing reasonable accommodations for documented disabilities. That objection, under any legally compliant process, should have paused any eviction action until a proper hearing could be held. Briarwood's property manager, a man named Gary Holt, who had built a reputation within the company for closing out difficult tenant situations faster than his colleagues, made the decision to proceed anyway, betting, as investigators would later determine was a common pattern in his handling of similar cases, that a tenant without significant legal resources would be unlikely to successfully challenge an illegal lockout after the fact, even if the lockout itself violated multiple state and federal protections. That Friday afternoon, while Danielle was in the middle of a work call, coding insurance claims from her kitchen table, Holt arrived at her apartment with a locksmith and two moving contractors, informed her through the door that she was being removed for lease violations, and began, over Danielle's repeated objections and her attempts to explain that her legal appeal was still actively pending, changing the locks and removing her family's belongings. "You have a pending objection on file," Danielle told him, her voice shaking but firm, standing in her doorway as the locksmith worked behind her. "You cannot legally do this while that objection is under review. I have documentation. Please, just give me a chance to show you the paperwork." "That's between you and corporate," Holt said, according to a recording Danielle managed to capture on her phone in the final minutes before her access to the apartment was fully cut off. "I've got a schedule to keep." Danielle spent the next 20 minutes moving between her doorway and her kitchen table, trying, with shaking hands, to locate the printed copy of her objection filing among a stack of paperwork she'd carefully organized precisely for a moment like this. A moment she had genuinely believed, given her attorney's assurances that the pending objection legally protected her, would never actually arrive. By the time she found it, the moving contractors had already begun carrying furniture out to the parking lot, and the locksmith, working from a separate instruction sheet that made no reference to any pending legal matter, had nearly finished rekeying the front door. Mia, then 7, stood pressed against the hallway wall throughout most of the encounter, watching strangers carry her family's belongings past her, asking her mother in a small, frightened voice why the men were taking their things. Danielle has said, in the time since, that keeping her voice calm enough to answer her daughter in that moment was one of the hardest things she has ever had to do. "I told her we were going to figure it out," Danielle said. "I didn't actually know that yet, but I knew she needed to hear it." By 4:50 that afternoon, Danielle stood on the curb outside the building she had called home for nearly 3 years, her 7-year-old daughter Mia crying beside her, her 4-year-old son Ethan clutching a stuffed animal that had been thrown, along with the rest of their belongings, into a growing pile on the wet pavement as a light rain began to fall. She sat down on the curb, pulled both of her children close, and, after several long minutes, simply trying to steady her own breathing enough to speak clearly, called her brother. Marcus Voss was in his chambers, finishing a written opinion on an unrelated civil case, when his phone rang with his sister's name on the screen. He almost let it go to voicemail, assuming, given the hour, that it was simply their regular check-in call arriving a day early. He answered anyway. "Marcus?" Danielle's voice broke almost immediately, something Marcus would later say he had rarely heard from his sister, even during the hardest months following her accident. "They just locked us out, me and the kids. We're sitting on the curb. I don't know what to do." Marcus, according to 2 clerks present in his chambers at the time, was on his feet and moving before the call had even ended, instructing one clerk to pull every filing associated with Danielle's building's ownership entity while he stayed on the phone with his sister, keeping his voice deliberately calm, even as he began, in real time, understanding the scale of what had just happened to her. One of those clerks, a second-year law graduate named Priyanka Shah, later described the following 90 minutes as unlike anything she'd witnessed during her clerkship. "He never raised his voice once," she said. "He was pulling case law on emergency tenant relief with one hand and texting his sister reassurance with the other, and somehow managing to sound completely steady, doing both at the same time. I remember thinking, this is what it actually looks like when someone knows exactly how a system is supposed to work and is furious that it isn't working that way for the person he loves most. I need you to stay exactly where you are," he told her. "I need you to keep the kids warm and dry, if you can find any kind of cover nearby. And I need you to know that I am handling this right now. This is not going to stand." What Marcus did next was not, strictly speaking, an ordinary use of his judicial authority, a distinction he would later be extremely careful to draw, both publicly and in his own internal ethics disclosure, once the broader case unfolded. He did not personally preside over any matter involving his sister, a recusal he insisted on immediately and formally, in writing, the same evening. What he did instead was use the full weight of his professional network and his own deep familiarity with emergency legal procedure to make sure Danielle's situation received attention at a speed that, by his own later admission, an ordinary tenant in her position would almost certainly never have received. He called a colleague, a fellow federal judge who happened to have emergency duty coverage that particular Friday evening, and, without requesting any special treatment for his sister's underlying case, formally alerted him to what appeared to be a facially illegal lockout in violation of established tenant protection statutes, providing the specific address and circumstances as any concerned citizen reporting a potential legal violation might. He called the local legal aid clinic that had been assisting Danielle with her pending objection, informing them of what had happened and asking, directly, what emergency relief options existed. And he called Danielle's own local housing court clerk's after-hours line, a resource he was aware of specifically because of his professional familiarity with the court system, rather than through any special access unavailable to the general public. The legal aid attorney handling Danielle's original objection, a young lawyer named Ricardo Suarez working his third year at the clinic, later described receiving Marcus's call as one of the more surreal moments of his early career, not because a federal judge had called him personally, but because of how carefully Marcus framed every part of the conversation, to avoid any appearance of pulling rank. He kept saying, "I'm calling you as Danielle's brother, not as anything else, and I need you to tell me honestly what options actually exist here, using the exact same process you'd use for any other client," Suarez recalled. He was almost more careful about that boundary than I would have expected anyone to be, given how upset he clearly was underneath it. It made the whole thing feel less like influence and more like someone simply making sure the existing system actually got a fair chance to work at the speed it was designed to work at. Within 2 hours, an emergency motion for immediate reinstatement of tenancy, prepared jointly by Suarez and reviewed on an expedited basis given the clear, documented illegality of proceeding with a lockout during an active pending objection, was filed with the on-call judge. By 8:30 that evening, less than 4 hours after Danielle first sat down on that curb, an emergency order had been signed, directing Briarwood Property Group to immediately restore Danielle's access to her unit, restore her belongings, and formally halting any further eviction action pending a full hearing on the merits of her original objection. The on-call judge who signed that order, reviewing the filing later that evening, according to court records, noted in his own brief, written comments accompanying the order, that the underlying facts presented, one of the clearest cases of facially improper landlord conduct this court has encountered in recent memory, language that, while routine in its procedural function, would later be cited repeatedly by the Attorney General's office as independent judicial confirmation that Danielle's case involved no special treatment, simply a properly functioning emergency process applied to genuinely and obviously improper conduct. Gary Holt, still at the property that evening overseeing the disposal of belongings from a separate, unrelated unit, was informed by his own regional supervisor, roughly 45 minutes after the order was signed, that he needed to personally return to Danielle's building immediately to comply with a court order neither of them had anticipated moving anywhere near this quickly. "I've done 100 of these," Holt reportedly told his supervisor over the phone, according to testimony later given during the broader investigation. "Nobody moves this fast on a routine lockout complaint. Something's different about this one." What was different, though nobody at Briarwood yet fully understood it that evening, was less about any special legal privilege attached to Danielle's case, and more about the fact that, for the first time in what investigators would eventually determine was a pattern stretching back nearly a decade, someone directly affected by Briarwood's practices had immediate access to a person who understood exactly which levers to pull, and exactly how quickly the existing legal system, when properly and promptly engaged, was actually capable of moving. Danielle and her children returned to their restored apartment just after 9:30 that evening. Their belongings, somewhat worse for wear after several hours of exposure to the rain, but largely intact, carried back inside by the same contractors who had removed them hours earlier. The rain had picked up steadily through the evening, and several of Mia's school books, left in a box near the bottom of the pile, were damaged beyond saving. A small, almost absurdly mundane casualty of the entire ordeal that Danielle has said, oddly, sometimes upsets her more in memory than the larger, more frightening parts of that day. Mia, still shaken, asked her mother if they were going to have to leave again. Danielle, according to an interview she gave months later, told her daughter something she has said she still thinks about often. "I told her no, we weren't leaving again, not because I was completely sure that was true in that moment, but because I needed her to feel safe enough to sleep that night." It wasn't until the following week, once we understood how serious this had actually become, that I really believed it myself. What began that Friday evening as an emergency reinstatement of a single tenancy expanded, over the following weeks, into something considerably larger. Marcus, still formally recused from any direct judicial involvement in his sister's case, nonetheless found himself, through his own professional network, connected to an attorney within the state's Attorney General's office who specialized in landlord-tenant fraud and pattern housing violations. A connection he made not by directing any investigation himself, but simply by making a single introductory call, informing that attorney of the specific documented facts of Danielle's case, and stepping back entirely from any further involvement. That attorney, reviewing Danielle's case alongside publicly available eviction filing records for Briarwood Property Group, quickly identified something that would have taken an ordinary tenant, or even an ordinary tenant's attorney, working a single case in isolation, months or years to uncover on their own. Briarwood had filed, or attempted to execute without proper filing, no fewer than 31 similar eviction actions over the preceding 4 years, disproportionately concentrated among tenants receiving disability benefits, housing assistance vouchers, or fixed income retirement benefits. Tenants, in other words, precisely matching the profile Briarwood's own internal portfolio optimization documents, once subpoenaed during the following months, explicitly identified as priority targets for removal. The subpoenaed documents themselves, once entered into the public record as part of the eventual settlement, painted an unusually explicit picture of the company's internal strategy. Spreadsheets tracking individual units by current rent versus estimated market rent, tenant profiles flagged by benefit type, and internal training materials for property managers that, while never using language explicit enough to constitute an outright admission of illegal intent, nonetheless walked new hires through a step-by-step process for building what one training document called a documented pathway to transition for tenants identified as high-value optimization targets. Investigators found particular significance in a company-wide email sent roughly 18 months before Danielle's own case and later entered as key evidence, in which a regional Briarwood executive praised Gary Holt by name for what the email described as his efficient handling of legacy lease transitions, specifically citing his closure rate on such cases as a model for other property managers to follow. Evidence, prosecutors would later argue, that Holt's conduct was not an isolated bad actor's individual failure, but a pattern actively encouraged and rewarded at the highest levels of the company's regional leadership. Of those 31 prior cases, investigators determined that at least 11 had involved lockouts executed, exactly as in Danielle's case, while a formal tenant objection or appeal remained legally pending, a pattern that, once fully documented, formed the basis for a formal civil enforcement action filed by the State Attorney General's office against Briarwood Property Group roughly 10 weeks after Danielle's own lockout occurred. Gary Holt was terminated from his position at Briarwood within a month of the initial incident, though investigators later noted that his termination, while framed publicly by the company as an isolated response to one employee's poor judgment, occurred only after it became clear that his conduct in Danielle's case was likely to become central to a much larger legal exposure the company was facing, a termination timeline that the Attorney General's office specifically flagged in its filing as evidence that Briarwood's leadership had been fully aware of Holt's pattern of conduct well before Danielle's case forced any accountability. Holt himself, deposed as part of the broader civil enforcement proceedings roughly 8 months after his termination, offered testimony that investigators later cited as particularly revealing of the broader institutional culture at Briarwood. Asked directly whether he had understood, at the time, that proceeding with Danielle's lockout while her objection remained pending was legally improper, Holt's answer, according to the deposition transcript, later entered into the public record, was strikingly candid. "I understood it technically wasn't supposed to happen that way," he said, "but I also understood that closing out difficult units quickly was what got you recognized at that company. Nobody ever told me explicitly to break the law. They just made it very clear what got rewarded." and what got you labeled as someone who couldn't handle the harder cases. That single exchange, replayed widely once the deposition became public, became one of the most frequently cited pieces of the entire case in subsequent media coverage. Not because it excused Holt's individual conduct, but because it captured, in his own words, exactly the kind of institutional incentive structure that had allowed the pattern to continue undetected for nearly a decade. News coverage of Danielle's case, once the broader 31 case pattern became public, extended well beyond local outlets, drawing national attention specifically because of how thoroughly documented the pattern turned out to be. A level of evidentiary clarity that housing advocates said was rare in cases of this kind, where individual tenants' isolated experiences typically never get connected into the kind of systemic picture that can actually drive policy change. Several national outlets specifically credited Marcus Voss's quick, procedurally proper intervention as the catalyst that allowed the broader pattern to surface at all. Coverage Marcus himself, according to people close to him, found uncomfortable, given how insistently he continued to redirect credit toward the existing legal aid and investigative systems that, in his view, had simply been allowed to work as intended once properly and promptly engaged. The broader civil enforcement action, once fully litigated over the following 14 months, resulted in a settlement requiring Briarwood Property Group to pay a combined total of $7.8 million in restitution and penalties, funds directed toward compensating identified victims among the 31 prior cases, many of whom investigators had painstakingly tracked down over the preceding year, had never realized their individual, isolated bad experience with the company was actually part of a documented, systematic pattern. Locating those 31 prior tenants proved to be one of the more logistically demanding aspects of the entire case, given how much time had passed since some of the earliest identified incidents, and given that several tenants had since moved multiple times, changed phone numbers, or, in at least 2 cases investigators eventually confirmed, experienced periods of housing instability directly traceable back to the financial disruption caused by their original illegal eviction. A dedicated outreach team within the Attorney General's office spent nearly 8 months on the location effort alone, ultimately identifying and confirming 26 of the original 31 affected tenants, with the remaining 5, despite extensive effort, never successfully located before the settlement funds were finalized and distributed among those who had been found. Restitution amounts varied significantly across the 26 located tenants, calculated individually based on documented moving costs, temporary housing expenses, lost wages associated with the disruption, and, in cases involving tenants with documented disabilities, additional compensation for the specific harm caused by losing accessibility accommodations that had taken months or years to properly establish in a new unit. One of those tenants, an elderly retiree named Harold Whitfield who had been illegally locked out of his unit nearly 3 years before Danielle's own case, told a local reporter, once the settlement was announced, that he had simply assumed, at the time, that he had done something wrong. Harold, a retired postal worker living on a fixed pension, had been targeted, investigators later determined, using the exact same pattern later used against Danielle, a series of minor, individually resolvable violations, building toward a final pretextual notice, followed by a lockout, executed while his own informal objection, filed without the benefit of legal aid representation he didn't know existed, sat unresolved. Unlike Danielle, Harold had no attorney, no formal appeal on file, and no family member with the knowledge or standing to intervene on his behalf. He moved into a smaller, lower-quality unit across town within a week, absorbing the loss quietly, the way he said he'd absorbed most difficulties throughout his life. "I didn't have anybody to call," he said. "I figured it was my fault somehow, that maybe I'd missed something in my lease, and I just found a new place and moved on with my life. I didn't know it was happening to other people too. I didn't know it was something anybody could actually be held responsible for." When investigators located Harold during their review of Briarwood's prior case files, he initially assumed, he later admitted, that he was somehow in trouble himself. It took nearly 20 minutes on the phone with an investigator from the Attorney General's office before he fully understood that he was being contacted as a victim, entitled to restitution, not as someone facing further consequences. He ultimately received just over $41,000 as part of the broader settlement. Compensation, he said, that mattered less to him than simply finally understanding that what happened to him hadn't been his fault at all. The settlement also mandated a complete overhaul of Briarwood's internal eviction and lockout procedures, including a new requirement that any pending tenant objection or appeal automatically halt all eviction action company-wide until formally resolved through proper legal channels, closing the exact procedural gap that had allowed Holt to proceed against Danielle and against at least 11 other identified tenants, despite active, pending objections that should have legally prevented any lockout from occurring. Danielle's own individual case, resolved separately from the broader civil enforcement action, concluded with her original wheelchair ramp objection being formally upheld, her right to the accommodation confirmed under federal fair housing law, along with a separate financial settlement covering damages related to the illegal lockout itself. She used a portion of that settlement, once finalized, to relocate her family to a ground-floor unit in a different building specifically designed with full accessibility features, a move she had been quietly hoping to make for over a year, but had never felt financially able to pursue. The move itself, completed roughly 5 months after the original lockout, carried its own quiet significance for Danielle beyond simple physical accessibility. The new building included a shared community room where she began, within weeks of moving in, hosting an informal monthly gathering for other tenants with disabilities to share information about their rights and connect with local advocacy resources. A small, grassroots effort that has since grown, through word of mouth, to regularly draw 15 to 20 residents from across the surrounding neighborhood. "I didn't set out to become any kind of advocate," she said. "I just remember so clearly what it felt like, not knowing which resources existed or which phone calls actually mattered. If I can shorten that learning curve for even one other family, that feels like the most useful thing I can do with what happened to us." Marcus Voss, for his part, gave exactly one public statement about the broader case, released through a written statement rather than any press conference, specifically because he remained careful throughout the entire process to maintain clear separation between his personal involvement as a brother and any appearance of judicial influence over an active legal matter. "What happened to my sister was wrong, and I am grateful that the systems designed to protect tenants in situations like hers were ultimately able to work as intended once properly and promptly engaged," the statement read. "What troubles me most, having now seen the fuller picture of what this company did to dozens of other families over many years, is how many of those families never had someone in their corner who understood exactly which door to knock on, and how quickly. That gap between what the law promises on paper and what people without resources or connections can actually access in practice is the real story here, far more than any single phone call I happened to be able to make for my own sister." That statement, quoted widely once the settlement became public, became something of a touchstone in broader policy conversations that followed at the state legislative level, where lawmakers, citing Danielle's case directly, eventually passed new tenant protection legislation requiring landlords to provide written, plain language notice of tenants' appeal rights before initiating any eviction action, legislation that housing advocates had been unsuccessfully pushing for years before Danielle's case finally provided the kind of clear, well-documented example that made the underlying problem impossible for legislators to continue ignoring. The bill's chief sponsor, a state representative who had introduced nearly identical legislation twice before without it ever making it out of committee, later said publicly that the difference, the third time, wasn't the substance of the bill itself. It was that Danielle's case, and the 31 prior cases uncovered alongside it, gave legislators something they'd never had before: a fully documented, legally established pattern, rather than the scattered individual anecdotes that advocacy groups had struggled for years to present as anything more than isolated incidents. "We'd heard versions of this story 100 times before," the representative said during floor debate ahead of the bill's eventual passage. "What we'd never had was a case where every single piece of it had already been proven in a court filing, tenant by tenant, pattern by pattern." Ms. Voss's case didn't just help her family, it gave the rest of us the evidence we needed to finally do something we should have done years ago. The legislation passed with rare bipartisan support, and similar bills, citing Danielle's case by name in their own legislative findings, were subsequently introduced in 3 neighboring states within the following year. Danielle Voss, now settled with her children in their new, fully accessible apartment, has since become an occasional volunteer with the same legal aid clinic that first helped her file her original objection. Not in any formal legal capacity, but simply as someone willing to sit with newly displaced tenants during their first frightening hours after a lockout, offering the kind of calm, practical reassurance she remembers desperately needing herself on that wet curb before her brother's phone call changed everything. She has, over the 2 years since the settlement, worked directly with 14 other tenants navigating disputes with different landlords entirely, none connected to Briarwood, all facing versions of the same fundamental problem. A system whose protections exist clearly on paper, but which most people, without any prior experience or family connection to guide them, have no practical way of accessing quickly enough to matter. "I tell people the same thing every time," she said in one of the only interviews she's given about the experience. "You are not alone in this, even when it feels like you are. There are people and systems that exist specifically to help you, even if it doesn't always feel that way in the moment." I got lucky that my person happened to be a federal judge. Most people's person is a legal aid attorney working 3 cases too many, or a stranger at a nonprofit who happens to pick up the phone that day. Those people matter just as much. They just don't always move quite as fast. Her daughter Mia, now several years older, has said, in the rare moments the family has spoken publicly about that Friday afternoon, that what she remembers most clearly isn't the fear of sitting on the curb, but the specific moment her mother hung up the phone with her Uncle Marcus and turned back to her and her brother with an expression Mia has described, in her own words, as the first time that whole day she looked like she believed things were actually going to be okay. Ethan, too young at the time to form clear memories of the lockout itself, has grown up instead with a different, quieter inheritance from that afternoon. A family story, told gently, and without dwelling on its harder details, about the day his mother refused to let anyone convince her that she and her children didn't matter enough to fight for. Danielle has said she plans to tell both of her children the fuller version of that story once they're older, not as a tale of victimhood, but as proof, in her words, that showing up calm and prepared, even on the worst day of your life, is sometimes exactly what changes the outcome. If this story made you think twice about power, about accountability, and about how many families never get the phone call that changed everything for Danielle, do 3 things for us right now. Hit that like button, drop a comment telling us what part of this story stuck with you the most, and subscribe so you never miss the next story of justice, resilience, and the fight for real accountability. 31 families, nearly a decade, and it took one phone call to a federal judge to finally force anyone to look at all of them together, instead of one quietly ignored complaint at a time. Imagine what could change if every family's complaint got that same level of attention, not just the one that happened to reach someone with the power to make 5 hours feel like justice instead of another year of waiting. We'll see you in the next one.